All right. I'm going to call this meeting to order for the Polk County Board of Commissioners for Wednesday, October 23rd, 2024. All commissioners are present. Announcements are on the agendas. Extra copies are on the side table. First item up is for comments for items that are not on this agenda. Do you wish to speak to the board, sir?
Oh, yes.
Yeah, this is your opportunity. Please step forward, give us your name and address for the record. You have 3 minutes.
Okay, my name's Robert Greenway, 2223 Southeast Academy Drive. And I'm here to talk to you guys about your DA's office. I understand that the DA's office belongs to the county, but that this guy here, Felton, is elected and paid for by the state. So I'm working with the Secretary of State to get his ass gone because he's corrupt and he's a liar, and I have proof. Okay, I've dealt with him trying to get answers. I've talked to Mr. Morgan Smith, sent him the information on there. You know, you guys should have control over your DA's office. There's crazy things going on there. Supposedly a police officer that accosted me at the Edgewater BCD office supposedly called 2 people at the DA's office and got instructions on what they can do with me. All he knew that it was 2 ladies. He called. Then they said, well, they don't have an answer. They have to call back. So one of the ladies called back. He has no idea who he talked to. He didn't get a name or anything. So right now I'm in the process. I got a hearing on December 4th with the board, what is it called? The Citizens Review Board for the Salem, to find out what's going on, because somebody between this officer, Rez, R-E-N-Z, and the 2 supposed ladies in the DA's office who told him something which nobody is professing to know anything about. I've talked to Felton about it. He washes his hands of it. That's why I went to the state office. You guys pay for the DA's office, okay? And I've already talked to Mr. Morgan about finding out what the hell, excuse the thing, went on, you know, with that. I think I deserve an answer, because some of the things that they said were just ludicrous, because I was having meetings and stuff with the BCD on Edgewater, which is a state office, Building Codes Division, because they're some of the things they're doing is wrong. So I'm trying to get them straightened out on it. So what they do when I go there is they call, and they call security, and they call the police, and they try to have me trespassed. Okay, so the answer that supposedly this officer got from the DA, and get this, is I can't be there if I ask the same questions that I've asked in the past. Okay, in other words, go over the same things that they won't give me answers to. What he came, pardon me?
That's not.
If I just stop in the middle, you don't want to hear the rest of it?
No, sir. Wait, we have 3-minute rule for a reason. So thank you. Appreciate it.
There's nobody else here.
Thank you. All right, next item is approval of the agenda.
Also move.
Second.
It's been moved and seconded. All those in favor signify by saying aye.
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 I'll be back next week to finish up then.
Okay. Approval of the minutes from October 16th.
I move approval.
I'll second.
It's been moved and seconded. All those in favor signify by saying aye.
Aye.
Aye. Passed unanimously. Approval of consent calendar.
Also move.
Second.
It's been moved and seconded. All those in favor signify by saying aye.
Aye.
Aye. Passed unanimously. Polk County Ordinance 24-06. Mr. Smith.
Morning, Commissioners, members of the board. This is the first reading of proposed ordinance number 24-06 in the matter of adopting an ordinance for the Polk County Sheriff's Office to provide a fair and efficient guidelines for tows. Whereas the Polk County Sheriff's Office has adopted what is labeled Policy 502, which is attached as Exhibit A to this ordinance. It is a policy outlining the processes and procedures for towing vehicles. The Polk County Board of Commissioners ordains as follows, that the Polk County Sheriff's Office Policy 502 attached as Exhibit A to this ordinance and incorporated into this ordinance is hereby adopted as the Polk County tow policy. Should any section or portion of this ordinance be held unlawful or unenforceable by any court of competent jurisdiction, such decision shall apply to only the specific section or portion thereof directly specified in the decision. All other sections or portions of the ordinance shall remain in full force and effect. I will now read Policy 502 from the Sheriff's Office. So bear with me here, but this will be fun. So Policy 502 from the Polk County Sheriff's Office is labeled Vehicle and Towing, Section 502.1, Purpose and Scope. This policy provides guidance related to vehicle towing. Nothing in this policy shall require a member of the office to tow a vehicle. 5.502.2 Towing Services. The Polk County Sheriff's Office maintains contracts with qualified tow companies and utilizes the non-preference tow list. When a vehicle is being held as evidence in connection with an investigation, when it is otherwise necessary to impound a motor vehicle, this would include situations involving the recovery of stolen or abandoned vehicles and the removal from the streets of vehicles obstructing traffic in violation of state or local regulations, when the need arises for a sheriff's office vehicle to be towed. Section 502.2.1, non-preference tow services. Upon proper application, the office may approve qualified towing services to be called when a citizen needs towing but has no preference as to which service to call. Tow contractors agree to arrive within 30 minutes of being dispatched. However, there are times when the ability to do so is outside of their control. It is suggested that deputies call to check the time of actual dispatch and or estimated time of arrival before deciding to have another tow company dispatched. Any complaint alleging a violation of the agreement or other misconduct by a non-preference operator shall be referred to the sergeant assigned to tow contracts for investigation. The office may periodically review the performance of each authorized non-preference operator. The office will assist citizens by calling any tow company desired. If the citizen has no preference and requests tow services, one of the authorized firms shall be called in rotation. All deputies are specifically prohibited from directly or indirectly soliciting for or recommending any garage or tow service. 502.3 impounded arrest scenes. Whenever a person in charge or in control of vehicle is arrested, it is the policy of this office to provide reasonable safekeeping by leaving the vehicle secured and lawfully parked at the scene, unless the arrested party requests to arrange for someone to pick it up, or if they request the vehicle to be towed at their expense. Deputies should allow a reasonable amount of time for a person to arrive to retrieve the vehicle. While the Oregon revised statutes may authorize the impoundment of a vehicle, such as driving with a suspended or revoked license pursuant to ORS 809.720, impounds are only authorized if in such cases where leaving the vehicle would create a hazard or obstruction. An exception is for tows due to not having insurance, which is authorized by statute and policy. In all such cases where a vehicle remains at the scene, the handling employee shall inform the arrestee and note in the report that the office will not be responsible for theft or damages. 502.4, impounds related to criminal investigations. Vehicles that are needed for the furtherance of an investigation or prosecution of a case or otherwise appropriate for seizure under ORS 133.535 may be appropriate for impound and storage and as evidence. Generally, a warrant to seize a vehicle is required for an impound to take place. The time needed to apply for a warrant to search a vehicle and not having enough personnel to monitor the vehicle in place is not in and of itself a reason to tow and store the vehicle without a warrant. That being the case, deputies should consider if both the seizure and the search should occur where the vehicle is located, if it is thought retention will no longer be necessary once complete and can be done safely. State law requires the impounding deputy to take reasonable steps to protect against loss or damage to impounded vehicles and any contents that may have been taken as evidence pursuant to ORS 133.537. Deputies should make reasonable efforts to return a recovered stolen vehicle to its owner rather than store it, so long as the vehicle is not needed for evidence. If a recovered stolen vehicle is towed, the deputy shall share the owner's contact information, including the person's home address and telephone number, with a towing service that assumes control of the vehicle. Deputies unable to contact an owner while at the scene should make reasonable efforts to reach them at a later time to advise them of the recovery. 502.5, vehicle inventories. All contents of impounded vehicles shall be inventoried in accordance with the following procedures. An inventory of personal property and the contents of open containers will be conducted throughout the passenger and engine compartment of the vehicle, including but not limited to the glove box, other accessible areas under or within the dashboard area, any pockets in the doors or in the back of the front seat, and any console between the seats, under any floor mats, and under the seats. In addition to the passenger and engine compartments as described above, an inventory of personal property and the contents of open containers will also be conducted in the following locations. Any other type of unlocked compartments that are part of the vehicle, including but not limited to unlocked glove compartments, unlocked vehicle trunks, and unlocked car top containers. Any locked compartments, including but not limited to locked glove compartments, locked vehicle trunks, locked hatchbacks, and locked car top containers, provided the keys are available and are to be released with the vehicle to the third-party towing company, or unlocking mechanism for such compartment is available within the vehicle. Closed containers located either within the vehicle or any of the vehicle's compartments will not be open for inventory purposes except for the following, which shall be open for inventory: wallets, purses, coin purses, fanny packs, personal organizers, briefcases, or other closed containers designed for carrying money or small valuables, or closed containers which are designed for hazardous materials. Other closed containers shall be opened and inventoried if the owner acknowledges they contain cash in excess of $10 valuables or a hazardous material. The inventory is not a search for evidence of a crime. However, deputies shall seize the evidence or contraband located during the inventory. Items should be scrutinized to the extent necessary to complete the inventory. Tow truck operators are to receive a copy of the tow report. These inventory procedures are for the purposes of protecting an owner's property while in the sheriff's custody, to provide for the safety of deputies, and to protect the office against fraudulent claims of lost, stolen, or damaged properties. Section 502.6, vehicle searches. Case law regarding search and seizure is ever changing and frequently subject to interpretation under the varying facts of each situation. Vehicle searches should be handled according to current training and under a deputy's familiarity with relevant case law. Generally, a search warrant should be sought prior to conducting a search of a vehicle. Based on circumstances under which a warrantless search of a vehicle might be permissible are very limited. Because vehicle searches are subject to many restrictions, deputies should, whenever possible, seek supervisory approval before conducting a warrantless search of a vehicle. Section 502.7, security of vehicles and property. After a thorough inventory of a vehicle has been completed and all contraband evidence and weapons have been removed, the deputy should make reasonable accommodations to permit a driver or owner to retrieve small items of personal value or personal needs, such as cash, jewelry, cell phone, and prescriptions. If a search of a vehicle leaves the vehicle or any property contained therein vulnerable to unauthorized entry, theft, or damage, search personnel shall take such steps as are reasonably necessary to secure and or preserve the vehicle or property from such hazards. Section 502.8, release criteria. A vehicle impounded under this section shall be released to a person entitled to lawful possession of the vehicle upon compliance with the following: proof that a person with a valid driving privileges will be operating the vehicle, proof of compliance with financial responsibility requirements for the vehicle, payment of the Polk County Sheriff's Office administrative fee and any towing and storing charges. A security interest holder in the vehicle is not required to comply with sections A and B and may obtain release by paying the administrative fee, towing, and storage fees. 502.9, records. Records section members shall ensure that pertinent data regarding towed vehicles promptly entered into the appropriate database. 502.9.1, vehicle storage report. Office members towing a vehicle shall complete a vehicle tow report. The report should be submitted to the records section as soon as practicable after the vehicle is towed. 502.9.2, notice after tow. Within 48 hours, excluding weekends and holidays of a vehicle being towed, it shall be the responsibility of the records section to send a notice of tow to all registered owners and other having recorded interest in the vehicle. Notice shall be sent to such individuals by certified mail. The notice shall include that the vehicle has been taken into custody and towed, the identity of the appropriate towing authority, and the statute, ordinance, or rule under which the vehicle has been taken into custody and towed, the location of the vehicle or telephone number and address of the authority that will provide that information. The vehicle is subject to towing and storing charges, the amount of charges that have accrued to date, the notice, and the daily storage charges. That the vehicle and its contents are subject to a lien for payment of the towing and storage charges, and the vehicle and its contents will be sold to cover the charges if the charges are not paid by a date specified by the appropriate authority. And that the owner, a possessor, or person having an interest in the vehicle and its contents is entitled to a prompt hearing to contest the validity of taking the vehicle into custody and towing it, and to contest the reasonableness of charges for towing and storage if a hearing is requested in a timely manner. At the time within which a hearing must be requested and the method for requesting a hearing, and that the vehicle and its contents may be immediately reclaimed on presentation to the appropriate authority of satisfactory proof of ownership or right to possession, and either payment, of the towing and storage charges or the deposit of a cash security at a bond equal to the charges with the appropriate authority. And that concludes my reading of policy 502.
Good job.
Thank you.
Well done.
So no action needed at this time. We'll bring it back for a second reading in 2 weeks.
Thank you.
Questions, discussion? All right, hearing none. That concludes our regular agenda. Do we have a need for an executive session?
Yes, sir. The board will meet in executive session pursuant to ORS 192 sub 2D to consult with individuals designated by the body to conduct labor negotiations.
And after all that